These are the top 5 misconceptions about probate law that you should not believe. Are you worried about the probate process because of something you've heard that might not even be true? Today, we're busting the top 5 myths about the probate process that could be causing you unnecessary stress. Myth number 1, probate takes years to complete. While that can be true, it is not always true. So generally speaking, there are kind of 2 major categories of probate in the state of Missouri. Number 1 is what most people will think of when they're thinking of probate, and that is a full probate administration. When does this apply? Well, it applies when there's property in the deceased person's name that has no beneficiary set, has no transfer on death, has no joint owner, and the value of that property is more than $40,000. This requires, if it's within 1 year of death, it requires a full estate administration. Now, this can be supervised or independent. Supervised tend to be a little more document heavy. There tend to be more hearings. They tend to last a little bit longer because everything you do has to be supervised and approved by the court. In an independent administration, you don't have to do all those things. You can do a lot of it without court involvement entirely. In an independent full probate, usually we can see those resolved within 9 months to a year in the state of Missouri. Now, if we are beyond 1 year of death before we start, or if the assets are small enough, say under $40,000, or in some cases under 24, 20, 15, we can use other kinds of short form probate administration to dramatically expedite the probate process. For example, let's say you had $100,000 in a bank account or in a retirement account, and it's 2 years after death. Well, we can do what's called a determination of heirship case in Missouri, and that involves 1 court hearing. It's usually set about 8 weeks out, but once it's done, it's done. We get a court order, we take that to the bank or the brokerage, and we can get access to the money. If the assets are below $40,000, we can do a small estate affidavit. And those, depending on what county you're in, can be processed as fast as 4 to 6 weeks, sometimes even faster from the time of filing. If you're a spouse or the deceased person left a minor child, you can file certain what are called creditor refusal or spousal or minor refusal applications that can process the case just as fast, sometimes 3, 4, 5 weeks to complete the entire probate process. So it's not always terrible. It does not always take a ton of time. Myth number 2, probate costs a ton of money. Well, that is true in many states, but it's not always true in Missouri. For example, while a full probate will usually be done on the basis of a percentage-based fee, there's a statute in the state of Missouri that governs how much the attorney for the representative is allowed to get paid as a minimum fee, and how much the representative themselves is allowed to get paid as a minimum fee for the job of doing the work as a personal representative, okay? And that is usually anywhere from 2.5% to 4.5% of the estate. All right. And it's not all the estate either. It's only the personal property or real estate sold under order of the court. So in many cases, probate in the state of Missouri, we see fees range from, and that's for full administrations, right? For a full probate case, we generally see fees ranging anywhere from, $4,000 all the way up through $10,000 to $20,000 or more, depending on the size for those larger estates. Okay. You can see cases resolved for just a few $1,000s, right? So it really, really depends on your circumstances and what's going on. Now, to get a quote for your specific case, you would need to talk to an attorney in the state of Missouri to give you real guidance on what it would cost in your case, because it can vary a whole lot. Myth number 3, all assets have to go through probate. That is a myth. That is not true. Most assets, in many cases, don't have to go through probate at all. So if you had a beneficiary set on your bank account, if you had a joint owner on your bank account or house or brokerage account, those sorts of things pass automatically without probate, right? If you have a beneficiary on your IRA, your 401k, your retirement plan, that plan is not going to probate. It's going directly to that person. All they have to do is file a beneficiary claim form with the IRA or 401k provider. If it's a house and you have a beneficiary deed on the property, you may not need the house to go to probate either. So it really depends. That's part of the beginning investigation of a probate case, is figuring out what property actually needs to go to probate. Anything that's in a trust also does not need to go to probate. So something important to know about which assets go to probate. Myth number 4, the state takes everything if there is no will. It's actually surprising how many times I've heard this misconception from people who have called our office with questions or concerns about probate. A lot of people think that if they don't have a will, or if they don't handle the process correctly, that the money or assets go to the state. And this can be true, but only after a very long period of time where assets are not claimed by the heirs. As long as you start the probate process within a reasonable time and they aren't auctioned for taxes in the case of certain real estate, or assets aren't given unclaimed property and then a sheet to the state after several more years, as long as nothing like that has happened and you're doing your due diligence to be on top of it, those assets are not going to the state. They're going to go to the heirs of the estate, or the heirs as designated, or the beneficiaries as designated under the will. They're not going to go to the government. Myth number 5, wills automatically avoid probate, right? No, wills only speak through probate. They're a testamentary document that has no function at all. Unless it is taken to court and proven before a probate judge, a will disposes of probate property, right? And that's the property that's left in the decedent's name and has no beneficiary, has no joint owner. That property is what the will controls. So if you have like a beneficiary set on your bank account, the will doesn't control that. So what sometimes people do is they'll put I put my daughter as my primary beneficiary on my bank account, and my will splits all of my money among my kids 4 ways. Well, surprise, that bank account is going to your daughter by herself, and she has no obligation to share that. So it's important to understand which things the will applies to. It only applies to probate property, and the will only applies at all if it has been admitted to probate court and properly proven up. Okay, so very, very important piece of probate law to understand. And in Missouri, it's even more important to understand, because in Missouri, a will must be admitted to probate within 1 year of the date of death, or it's void. It is no longer usable as a will if that will is not admitted to probate within 1 year of death. So it's very important to, when somebody dies, if they had a will, look for it. If you don't know if they had a will, look for one, get in touch with an attorney, get it filed with the court if you want it to have any effect. Otherwise, that will may as well be torn up, thrown out the window. There can be rare circumstances where you can use it as evidence, but only really in litigation. The normal probate case is not going to respect that will at all. So understanding what probate really involves can help you better prepare for the future and avoid any unnecessary expenses and worries. So if you have questions about probate and need help with your estate planning in the state of Missouri, don't hesitate to reach out to a professional. Now, remember, this is what we do, right? So we are an estate planning and probate firm out of St. Charles, Missouri. We help families across the state with estate planning and probate in the state of Missouri, right? So like and subscribe if you found this video helpful, and comment below with any other myths you've heard about estate planning or any questions you might have. We might just feature your question in a future video. That's it for today, guys. Until next time.